Abby, that's because there are other abortion bans still on the books, still in effect here in Oklahoma that used different reasoning and different logic. But the two bills that were struck down today, the two laws by the state Supreme Court, enforced abortion bans using civil lawsuits.
We are pleased that House Bill 4327 and Senate Bill 1503 were struck down.
The Oklahoma Call for Reproductive Justice welcoming the state Supreme Court striking down Senate Bill 1503 and House Bill 4327 with a 6-3 ruling. Constitutional law professor Jeremy Tellman says the majority of justices agreed the laws prevented physicians from being able to properly provide an abortion when there's a medical emergency.
And the court wants that determination when necessary to preserve her life to be determined by a medical professional rather than the statutory language.
1503 banned abortions at 6 weeks or when a fetal heartbeat could be detected. 4327 banned abortions at conception. Both could be enforced through civil lawsuits, meaning anyone could sue any individual other than the pregnant woman who was involved in providing the abortion. The Speaker of the House, the Senate President Pro Tem, and Governor Kevin Stitt criticizing the ruling, Stitt going as far as say that the court's ruling was activist and political in nature. It's important to note that a law that reinstated a 1910 abortion ban remains in effect and has no exceptions for rape or incest.
Those are the laws that are in effect. And because that total ban and those pre-Roe laws are still in effect, they were not held unconstitutional. That is why we don't have abortion access in Oklahoma.
And Tamaya Cox-Ray, who you just heard from in that story, says the only way she believes that Oklahoma will fully restore abortion access is through a state question, modifying the state constitution, or having a federal law passed that would enforce access throughout the country.